Right. So for a charter question, how it will look like. So this is how, see, in one-on-one class, what we are aiming to do is that you need to get confidence in all the topics of constitutional law, right?
Okay.
And
Yeah.
that confidence will not just come when I teach you the concepts, because already concepts are taught, you have learned, you have studied, you have the notes with you, you have the
Mhm.
IRACs with you, you have the lecture recordings with you. If you have any doubt, you can also watch them. So for the next class, I would expect you to watch the recording of a topic that we are going to discuss and then come.
Yes.
Okay, so that
Okay.
it will be you'll
More
be
easier.
having the, yeah, you can recall the concepts as well, right? So today we are
Okay.
going to just do the section 15 so that you can watch the recordings. After this, what you have to watch? Start at section 15 you have to watch, okay,
Okay.
and
Mm-hmm.
then they will see section 7. Okay, because these
Okay.
two are like you mentioned, it is a bit difficult, right? So section 15 and
Yeah.
7, these two lectures I want you to watch it. Come for the next class where you will be
Mhm.
writing the answers. I will not be writing the answers.
Okay.
Now I'm just going to show you how it works, how you should do it from the next class.
All
So
right.
first I'll give you the question. So you have to split your screen into two, and one side you have to open the Word file. This is like,
Mm-hmm.
how it's there in your exam also.
Exam.
That one side
Okay.
you will be having, right? So you will choose the font, everything, right? And
Mm-hmm.
because neatness is very important, okay? Because it's not just for them to give you marks or, cut your marks. It's for your benefit also. Mentally, we will be having that, flow of thoughts. If the typing that you're doing is, something like Arial or something, for example, I'll just show you. Calibri, I hate Calibri. These wordings doesn't look that good. Ade,
Okay.
if I do Times New Roman, see the
Mm.
difference, right?
Yeah.
So the see
Yeah.
the
More
difference in
for.
the, yeah, formal, and also we feel that it is the flow of thoughts. It will not be obstructed by anything. Okay, so that is why these things are important. Choose a font size of 12 Times New Roman, because even though while writing here I usually use Palantine or Linotype, that's my favorite. But
Mm-hmm.
in or Bookman old style also, while writing assignment and all, I use this. But in the exam we don't have many choices, so I would go with Times New Roman to be very easy and quick and not think too much about it. And justify.
Okay.
This is also important. You have to justify the paragraph. That is like, equal on both sides. You can also do
Yeah.
paragraph, left intent, right alignment or left alignment or central. Of course, we won't write it. But this is the best way to write answers. How you write answers like this. This is the
Okay.
this is how it looks when you give the what is called justify. But if I
Justify.
write like this, it'll look like this. It's not bad. This is also fine. But see, this
Mm-hmm.
looks weird, right? So you have to go
Yeah.
with the justify option. Then line space also 1.5. I always use
Okay.
1.5 because that is not too much, not too less. So it's having a good, readability
Listen.
for the evaluator also. Because when you send me an answer, if I can't, it's not about the content. Content comes second. First impression is the best impression, they say, na? That's the
Mm-hmm.
only chance you get. So even the line spacing is also very important. Now coming to
Oh,
the content. After all this, if the content is, poor, then there is no marks for beautifying the whole thing, right? So content
yeah.
is important. So the next step that you're going to do is read the question, because here I will be telling you what is this question about, but in the exam the question is looks like this, where, right? It doesn't
Mm-hmm.
hint you on which question, like which topic it is on. It is not going to tell, right? So this is how the
Mm-hmm.
question will be, and from tomorrow I'll also be giving you a question like this without telling which topic it is. Of course, it might be on 15 or it might be on 7 also, because I'm giving you two topics to prepare for. Hmm? Out
Okay.
of those two, one question you'll do. So the
Mhm.
so you will start reading the question, but just give attention how I'm reading and how I'm highlighting. That's what you are supposed to do also.
Okay.
Okay. So let's start. Let me just Yeah. The fact, the province of New Maple enacted Public Housing Accessibility Act. So there is a legislation to address housing shortages and improve accessibility for marginalized communities. So they have given me, what is this? This enactment is for this purpose. So I have the purpose here, right?
Mm-hmm.
So I have the act, which is a provincial act, right? Provincial
Yeah.
act, and I have the purpose. See, now that I'm on the first paragraph, I don't know whether it is on DOP, whether it is on something else. So these are important for DOP also, right? So what is that act is for? Where is this act coming from? Provincial act, right? And this is the
Mm-hmm.
act's name, and this is the purpose. So as in when you're reading, you want to understand and memorize these things slightly. Under this Act, applicants for public housing are prioritized based on eligibility criteria. So they are prioritized. It's not equal for everybody. Again, prioritized. So you apply, I apply, 100 other people apply, but it is prioritized. They choose on a basis. What is that eligibility criteria? Eligibility criteria including income level, family size, and residency in province for at least 5 years. So they have a criteria. So I don't have the residency in New Maple. Okay, you are living there for at least 5 years, and you will be prioritized over me. So there is a priority, eligibility criteria, right? So whatever we apply for, requirements will be there, eligibility will be there. So they're talking about that. Danny
Okay.
Patel, a recent immigrant from India who has lived in New Maple for only 2 years, applied for public housing. So they are giving public housing, right? So public housing requirements is what? 5 years, but he is only living for 2 years. So we will underline 2 because 2 years is less than required. Applied for public housing despite meeting the income and family size criteria. There are other level also, income, low income, yes, family size, yes, but the third requirement did not fulfill. 5 year residency level, he was denied due to 5 year residency requirement. Danny contends that his requirement discriminates. This is a keyword. Why? Because discriminates. He only is saying. So in the exam, the question itself tells you what is this about, right? They have to give you a hint. Otherwise, how will you solve it, right? So this is the hint. Discriminates. So that characters will speak to you. Characters will tell you what is the topic. So either the government side will tell or the aggrieved party will definitely tell, right? Aggrieved party is here. Who is that? Danny. Danny is filing for what? Public housing. But he was denied. For what? Because he did not meet the 5 year residency requirement. So that is one of the priority requirements among income level, family size. The other two, he is eligible, but the third one, he is not. So he is saying that this requirement is discriminatory. So when this word comes, discriminates, that means we have charter right. So Danny is a lady, okay, her charter, okay. So, charter right. So, we know the topic is under charter rights, which section talks about discrimination?
Mm-hmm. 15.
15. So, there is no confusion. 15 is the answer, right? But of course, in the exam, they're not going to just give one section, they will mix it up, right? So, you know that
Yeah.
they will give in combination of 7 and 15, 2A and 15, 2B and 15, like that. So, that we are
Yeah.
going to do later, okay? So, first we'll see how individually we have to solve, then we will club it up and solve, okay?
Okay.
Yeah. So this is the word talking about section 15 against the recent immigrants and violates her charter right. The government defends. So the government is on the other side because it is their provincial law, right? It's their provincial law about Public Housing Accessibility Act. They have enacted it, so they have to defend it. If somebody is, you have written something, and against that I speak, you have written an assignment, and I tell that, that is discriminatory, then you have to defend it now because you have written it. You will say that, no, 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 that was not my intention. These are the requirements. That's how it's supposed to be, right? You have to defend it. So here the government is defending 5 year, defends the 5 year residency requirement as a key element of the Public Housing Act, Accessibility Act, asserting that it is necessary to prioritize access to limited public housing resources for long-term residents. So, what is their reason? So, why it is important? You are telling me it is difficult for you to connect the facts to the law, right? That's why we are reading the question in this manner, detailed manner, highlighting wherever it is requirement. Whatever I'm underlining, they are required to be taken to the answer. Your connecting points are there, no? They are here. These are the connecting points because see, when you're talking about defending or on the side of the government, you will take this point. Is there anything in the test that is asking about, defense, that is asking about this law is not bad, it is in fact good, right? So these are the good points towards the law. And on the other side, we have charter rights. Okay. So, by restricting eligibility to those who have resided in the province for a significant period, the government aims to ensure that the individuals who have demonstrated sustained economic and social contributions receive housing benefits. So, their point is this, they are saying, see, we are not discriminating, we are just giving those people a better, and we are just prioritizing those people who are having 5 year residency requirement because those are the people they're here for 5 years and they have contributed a lot to our economic and social benefits, right? So that's why we want them to also have something in back. Okay, that's their idea. But is it discriminatory? Sounds like. This approach is intended to balance the needs of the broader population while addressing housing shortages in an equitable and pragmatic manner. So, this is what they are contending. So, this whole paragraph is basically you can use not together, but in break by break. We will see how we are to write it. But this is entirely towards the government's defense.
Okay.
Okay, government's defense. Moreover, the government argues further, they're not done. Government argues that the legislation serves an important societal objective. What is that objective?
Okay.
Fostering community stability and ensuring effective management of scarce housing resources. So this is their objective. They're saying fostering community stability and ensuring effective management of scarce housing resources. So, in order to effectively manage, see, basically, public housing when they're giving, it's like sort of either on a subsidy basis or free, right? So, there are only limited number of public housing left. Okay, only 50 are there. So, 50 cannot be, on a first come first serve basis, right? So, I mean, it should be like that, but they are saying that we are just managing it effectively, so we are putting it restrictions. See, scholarship you are applying for. When you are applying for scholarship, will they give for everybody? No. They will either keep one exam. They'll have certain eligibility requirements. 95% and above students only can apply. Backward community or low income family people can only apply. People who have annual income of 1 lakh per Indian rupees. Talking about 1 lakh, less than 1 lakh can only apply. Only female candidates, right? Only rural candidates. So certain restrictions they will put or requirements they'll put so that it goes to the person who needs it the most.
Mm-hmm.
Okay, but here, do you see a loophole? Practically think about this question. They are saying 5 years who have been residing in this place will give them public housing. But is it required for him the most who has been living there anyhow for the 5 years, or for the person who is just coming to Canada? Who is there for 1 year, 2 years? He might be also requiring the most, right? So this seems like a what do you say, like a discrimination, but we can only call it a discrimination if it is recognized by the law. We can't say something that I don't like, I cannot call it discrimination unless the law recognizes it. Correct? So
Mm-hmm.
if the law under section 15 of the charter, if it says on basis of residency, does it say on the basis of residency? Do you recall? Section 15, we did. Section 15 of the charter, does
Mm-hmm.
it talk about residency as one of the charter rights? I'll just open the entire charter rights in front of you so that we can find. Section 15, equality rights. Every individual is, let me just zoom it out. Hmm, yeah, here it is. Equality rights. Every individual is equal before and under the law and have the right to equal protection and equal benefit of the law without discrimination and, in particular, without discrimination based on race, national or ethnic origin, color, religion, sex, age, or mental or physical disability. So till here, in 15 clause 1, they have given certain requirements. So they have told that these are the categories we are protecting on different race, different national, ethnic origin. But did they say anything about residency here?
Mm, no.
See, the person who is having 5 years residency in Canada might be from different nationality also. So they're not making category based on nationality here. Sure?
Oh,
Correct, no? 5 years who's living there, he's not a Canadian citizen. They're not telling it is only available for Canadian citizen. Are they telling that?
no, no, no. Just a
Yeah,
residency.
just the residency. Yeah, that is the trick, no? 5 years residency. If you're living there for 5 years, are you getting automatically, are you getting citizenship? No, you're not getting.
No.
Right? But
Yeah.
so here we can say that residency is not listed here. But what does it say here? Every individual is equal.
Mm-hmm.
Every individual is equal. Even this equality right is also not given just for the citizens. It is given for everybody.
Okay.
Everybody includes the person who is sitting in India like me, and I'm applying for immigration application. I want to come to Canada and I apply for visa, visitor visa, whatever sort of visa. And if they
Mm-hmm.
reject because I'm from this country or I am in particular, I'm from this particular region, then that is discrimination. I can ask, I also have charter rights of Section 15(1) is also protecting me, who is not even in Canada.
Yes.
Because you will see some places it is only available for citizens. Every citizen of Canada, mobility right is given only for Canadians. Every citizen of Canada has the right to enter, remain, and leave Canada, right? Every
Okay.
citizen of Canada and every person who has the status of permanent resident in Canada has the right to do these things. So they are
Oh,
telling under each charter right, every citizen, every person, everyone, fundamental freedoms of section 2A and B. We are learning no, for our exam. 2A and B is also given for everyone. This
mm-hmm.
15 is also given for every individual. So these are
Okay.
important, like wordings are very, very important in order to get the interpretation right. Then we are
Okay.
not done yet. Subsection 2 talks about does not preclude any law, program, or activity that has its object the amelioration of conditions of disadvantaged individuals or groups, including those that are disadvantaged because of race, national, ethnic origin, color, region, sex, age, or mental or physical disability. So, what is this second subsection telling? If there is any law that is making distinction, distinction specifically for protecting these people, that is also in a way discrimination, no? See, there are 5 people applying for a job application. Okay, job.
Okay.
Let us take a better example of grant. Okay, grant. You are applying for a grant. You are
Mm-hmm.
one of the candidates out of 5, and you are perfectly not falling under any of these categories. Okay, you're not falling under these categories. There are other candidates. There is one candidate who's of a particular ethnic religion or ethnic origin. For example, Aboriginal person. Okay, he
Okay.
is from Aboriginal person. Another person is there who is from 2S LGBTQ plus community.
Mm-hmm.
Okay, so they are from that community. So now, if that particular grant is specially made for 2S LGBTQ community, okay, then it will go to that candidate only, not to you, not to the other person, indigenous person, not to anybody else. It will go to them only because that law or that grant is coming from a particular act, right? So everything has to come from a particular law. Something has to authorize it, no? So that law, every law is basically under what? Constitution. Every law basically comes from Constitution, takes permission from the Constitution to run and have its authority. Then when that law is applying to other people, they have to adhere to the charter rights. Okay, that is basic.
Yeah.
Correct? Now,
Yes.
under some law, if they are giving some scholarship, some grant for particular community who is already discriminated, generally whoever is discriminated, and in order to protect them, they want to create a group. It's called, equal among equals, unequal among unequals. So I am perfectly all right, but my fellow candidate is, blind. They need assistance in writing the exam. They will be getting that. They will be put up in a separate room because they should not be disturbed. For me, I can see, right? I can see even a small, sound of disturbance, it doesn't disturb me as much as it disturbs them. So they will be
Yeah.
given additional requirements. They will be given 4 hours instead of me getting 3 hours. They'll be getting a person who will be typing instead of them, right? They can't see the question.
Oh,
They have to be, read the question. They have to be typed by someone else. So that is the, equal among equals. Are we equal? No, we are not equal. So I can't say it is discriminatory. I'm not getting 4 hours. I cannot say, for me also get me 4 hours and give me accommodation of another person, typing my answers because my hands hurt. I can't ask that, can I?
no.
Hmm. So that is the basic understanding of Section 15. That is,
Okay.
Section 15, specifically first part of the Section 15, Clause 1, it says that these are the equality basis. If anybody discriminates you based on race, nationality, ethnic origin, color, religion, sex, age, or mental or physical disability. But on the second side, they're saying, on the same physical disability here, I told my fellow colleague or candidate is blind. I am not, but it is a physical disability. So, because that person has physical disability, they're giving them extra accommodations. That is discrimination as I see it. But the law says no. Under subsection 2, it says no because they need extra accommodation. So we are protecting them. What is it called? It is called as amelioration of conditions.
Mm-hmm.
Ameliorations, or these are called as amelioration or protective programs, positive discrimination. These are the term used. Okay. Positive
Okay.
discrimination is allowed under ameliorative program under subsection 2 of section 15 of the charter. Did we get a good understanding of section 15 now?
Yes,
Yeah,
I
you should
did.
not forget this concept. Okay. Section
Okay.
15 says equality, equality for all the people. And if
Mm-hmm.
anybody discriminates based on the, you know, listed grounds, these are the listed grounds. Additionally, there are analogous grounds, citizenship, as per, Andrew case law, right? Then
Yes.
sexual orientation based on another case law, right? It is mentioned in the notes. So analogous ground is coming from case laws. So certain case law, see, law is there. After the law, what comes? Case law keeps updating the law, keeps updating the benefits. So it may increase or it may decrease also. So we have to be up to date with the case laws as well. So if your category here in the question is falling under section 15 clause 1 listed grounds, then straightforward you can say it is a discrimination. But again, you have to see, is it an ameliorative program? Is it positive discrimination? Here it does not sound like a positive discrimination because it is not giving the person who's having a 2 year residency, right? Residency as uh, same benefit as the other person who's having 5 year residency, right? So let us see.
Mm-hmm.
Here it is not a straightforward question. I am sure it is not a straightforward question. Because if it is on sex, only for men, we'll give the residency. No, it is not straightforward. So it is confusing. It is complicated. So we will see both the parties what they argue. That is where we get the hints to write the answers. So for the side of the government, we have to protect the law or to support the law that this is not discriminatory. We have the we have these points which says that these are the things that they are trying to do and it is not discriminatory.
So we
Without
will
such
write from the government side or we will write from the opposite side.
both sides. So when you are, writing constitutional law exam, you are not supposed to take any sides. You are
Oh,
supposed to analyze it like the judge. How the judge will see. Judge will make both sides argue. Like that only, here in the fact pattern, you can see both sides are arguing. Now you are the judge. You are to decide. You are to decide.
okay.
How will you decide? You will apply, you'll listen to both side argument, you will give connection to the law, you will apply the law and case law, and then finally you're giving the judgment. You're basically making the decision whether this law is discriminatory or not. They're giving you that power.
Okay. I'm pretty sure I did one side only.
Yeah, so that could be again a major reason for decreasing the marks.
Marks,
you're not
yeah.
supposed you're not supposed to support one particular party. In case the question, in case the question suggests that you are the lawyer for that Danny here, okay,
Oh,
she's coming to you, she's your client, okay,
okay.
or your supervising lawyer is a, solicitor for, lawyer for this particular Danny, and you are
Mm-hmm.
articling there, you are supposed to give a memo of, positives and negatives of this particular case and like write a memorandum for your supervising
Oh,
lawyer
like
to.
in the criminal law. Okay.
Exactly. Even then, you
Mm-hmm.
are supposed to analyze both sides, no? If you are telling
That's it.
your supervising lawyer about this case, then you are supposed to analyze both sides. You're supposed to
Yeah.
talk about both sides. Okay?
Okay.
Yeah.
Yeah.
Even if you
Yeah.
are the lawyer, you will analyze both sides before going to the court, right?
That's right. That's right. But I
Yeah.
didn't write it in the exam. I'm
So
pretty
in
sure.
NCA exam, you have to be very sure. However, the question is framed, it is best to talk about both sides because the question talks about both sides. Answer
Mm.
must address both sides. You have to say,
Oh.
yes, there are some points on the opposite side as well, right? Even if I am Danny's
Mhm.
lawyer, I will consider the opposite side. Then in order to, because as a lawyer in Canada, just imagine like in Canada, you are becoming a lawyer, you are not the client's, you're not supposed to lie for the client, you're not supposed to use the law in a way that helps your client. No, you're
No.
supposed to represent your client's best interest within the bounds of the law. Okay, there's a difference. You can't use the law for the client's benefit, and in case if they want to do some crime, fraud, misrepresentation, you can't help them. You have to withdraw. In PR, we have studied. We have to withdraw that time, right?
Mhm.
So, as a lawyer, you're the friend of the court. You are there as a, you're guiding the law. You are to abide the law first of all, right? And you are friend of the court. In the court, the judiciary basically, they are there to decide, to give justice. How can they give justice if the lawyers are, having their own game, right? So we are supposed
Mhm.
to help them to get to the truest of sex, right? Whatever is possible. So that's why the lawyers are basically representing their client to the best of their ability. It is not, helping the client go scot free. No, our agenda is not to win. Our agenda is to follow the law. Got it? So
Okay. Yeah, got it.
we will never go beyond the law. So here we will see, argument on the government side is more. They have given points, but here Danny so far only says that it discriminates. That's it. But we don't have any other points. We'll see what else is
Okay.
given. Without such residency requirement, it contends the influx of new applicants could overwhelm the system. See, they have given the reason. Is it a valid reason? We'll see later. But they have given a reason why they are saying. Otherwise, if they don't say 5 years, requirement we are not putting, then every Tom, Dick, and Harry who comes to Canada will start applying for public residency, and it will not be given for who actually intends to stay here for a long time. See, people who have given already 5 years to Canada, who have, suffered through the economy and all, right?
Yeah.
5 years
Yeah.
they have suffered. Definitely they're going to live there, right? They're going to give back to the community as well. See, the government's idea is not about, facilitating everyone. It has to be two-sided. We give you something, but what do we get, right? It will also be there, practically speaking. They don't tell it
Mm-hmm.
out loud, but that's how the government runs. They have to see the benefit of majority of the people, right?
Okay.
Yeah. So, thereby disadvantaging those who have built strong ties to the province and contributed to its economic growth. So they are basically saying that we will help them who have already helped us in our economic growth. So it's fair. That's what they're saying. Let's see, is it fair? The government further asserts that the residency requirement was implemented after weighing alternative approaches and it reflects a carefully calibrated decision. So they are saying they considered everything, alternative. Any alternative approaches is there, it is found to be best. They tried to see alternative, approaches. I think you would remember there's oak step for violation of charter rights. You can counter it with oak theft. You can save it with oak theft, right? So their alternative word is there. Was there any alternative thing? So here they are giving you hint in order to save us under oak test, right?
Okay.
Hmm. And it reflects a carefully calibrated decision. While it recognizes that requirement may create distinction between the groups, it views this distinction as an inevitable and acceptable consequence of achieving the broader goals of housing accessibility and public welfare. Broader goals. Again, this also word you will see in the Oxford. Broader goals, right? So
Oh,
is
yeah.
there,
Yeah.
yeah. So here, this is basically shouting at you to tell, like, save me under success, right? So the answer is there. Hint is there. You just have to apply it. But we can't keep it one-sided because here it says mostly government side. We can't keep it like that. We have to talk about what Danny feels, what, from Danny's side also we have to write.
Okay.
Ultimately, the government argues while the act may affect recent immigrants like Dani Patel, the broader benefits to the community outweigh the potential harm caused by the distinction. So they are accepting, yes, it may create the distinction between the groups, but how long can you see like a law cannot be perfect? A law cannot be perfect. There will always be some sort of loopholes, right? It will try to do its best, but it cannot be perfect. So definitely it will create a group of difference, right? Because that's why even section 15 clause 2 was had to be written. Otherwise, if it was not written, then I would say, no, it is discrimination because I can see you are giving me only 3 hours because my colleague or candidate cannot see you're giving them 4 hours. I can call that also as discrimination. That's why they had to mention 15 clause 2 to save it under ameliorative program. But here we can't use that. So let's see the broader benefits. So there's a broader benefit. It maintains that the requirement is proportionate. Again, all the hints towards Oakes test is given here. Response
Okay.
to a pressing response to a pressing societal issue, and that its design ensures fairness and rationality in its application. Check for the charter violations and consider whether these arguments align with the principles underlying Section 1 of the Charter, evaluating Act's validity. See, the Act's validity, when they are asking, it doesn't mean they are asking DOP question. They are asking you to check for charter violations.
Okay.
So both you have to see. See, an act, a law, can be invalid based on two things. Act's validity, we have to check under two things. What are those two things? First one is DOP, that is Division of
Power.
Legislative Powers. Legislative powers.
Power.
We usually miss this word. Students miss this word. We say DOP, DOP all the time. No. So people
Mhm.
forget this legislative power. Division of power, no. Division of legislative power. Division of legislative power, why it is important? Because under Constitution Act 1867, they had divided the power, legislative power. What is legislative power? What do you understand by legislative power?
It's the exercise of power to different organs of the bodies like parliament, executive.
That is why I told it is not division of power, it is division of legislative power. Does executive have legislative powers?
Um,
you
no.
told you told three organs of the state. Basically three organs are, what are the three organs? What are the three?
Parliament,
Parliament.
executive,
Mm-hmm.
and
Where are we
no.
going for filing the case?
Oh, the judiciary, sorry.
Yeah, forgot the main part. Okay, judiciary. Okay, so executive is the government part, right? Governing executive
Governing body.
politicians,
Right.
MPs, common House of Commons, all those things, right? Executive
Mhm.
section. Another one, judiciary. You know very well what is judiciary. The third one you said is parliament, which is also called as legislature,
Legislature, yeah.
because at the federal level we call it parliament. In the provincial level, we call it provincial
Legis
legislature. So you
Mhm.
can also call as, federal legislature or provincial. So you can call that category as either parliament or better legislature. Why I call it legislature? Because, legislative power is with legislature only.
Connected to. Mhm.
Can the judge, can judiciary pass a law? Can judiciary enact a law?
Yes.
Yes,
Like
enact.
in the
Draft and enact. Can they have you seen a judge or Supreme Court, or like any court basically giving a law? They do case laws.
no, and
Case laws
not
is
not
different.
enacting a law, but like the precedent decisions we
But
take.
that will be
No,
based on a law. That will be based on a law, right? He can't
yeah,
decide on a law.
enact a
He
law.
can't create a law. See, enacting means creating a law,
Okay.
right?
Yeah, they
He
are
cannot
creating.
create a law. Judiciary cannot create a law. Executive cannot create a law. They can always recommend. The
Yes.
legislature, they have to ask the legislature to do it because they have divided this power. See, separation of power is there between these three organs. They have separated chores. Now, in the house, husband, wife, and children, they all, if the children, considering children are 10, 12 plus. I don't know when children start doing house chores, let's say 10, 12 plus, right? So,
Mhm.
you'll ask one child to do the, dusting. You'll ask the another, whenever, Diwali or some festival comes, we do that, no? Division of labor, right? At the house.
Mhm.
The husband is supposed to get all the stuff that is required for decoration and all stuff. He'll take care of the lighting, you'll take care of the cooking, or vice versa, right? He'll take care of the cooking
Mhm.
if he's good. Like me, I'll like to, I don't like to cook. I like to take care of the decorations. So, so like that, we will divide our work. So that is basically happened. That is called as separation of power, not division of power. That is separation of power.
Okay.
Separation of power between three organs, executive, legislature,
And
and
judiciary.
judiciary. Right? This is the three organs of the state. They have separation of power. They have separated the power, or you can say, work. Right? This is basically division of labor. So executive take care of the, government, how the government should run. Legislature will take care of enacting the law. Judiciary will take care of maintaining and providing justice. Right? So they have divided their work. They don't overlap. Now,
Mm,
what is judiciary's work? Can anybody? We always have, okay, in foundation, there is a concept of independence, judicial independence. Why do we
mhm.
call it judicial independence? Because they should not be, influenced by either legislature or executive. But judiciary will follow the laws made by the legislature. But
Yes.
also, judiciary will say the law is invalid if the legislature is not following. Everybody's boss. Who's the boss?
Constitution.
Constitutional law. When we say constitutional law, it is not just a constitution act. It is, there are two acts, right? Two acts. What are those? 1867 plus
And 1980.
1982. There are two
Mm.
laws, okay, two acts to be precise. Then there are principles, unwritten constitutional principles. Principles. Okay. What are unwritten constitutional principles? We are going to learn detail in foundational law, right? We have learned there.
Mm.
Separation of powers is one of the things. Separation of power, nowhere it is written in constitutional act, but it is one of the unwritten constitutional principles,
Yeah.
right? Federal, what is that called?
Federalism.
Federalism. Yeah, federalism is
Federalism
not written anywhere, but it is unwritten constitutional principle,
and
right?
democratic. Yeah.
Yeah, so these things are together called as constitutional law. That's why we
No.
don't call it as constitutional act. We are learning constitutional law of Canada. We are learning all these things, right?
Okay.
Yeah. So these are basics. Okay, we should never forget this. These are basics that has to be there in your mind. See, that is why these one-on-one classes are better than group classes for
Mhm.
your doubts, because your doubts may not be other people's doubts. So in group,
That's
what
right.
happens, or in recordings, what happens? I have a syllabus to follow. I follow the syllabus. But in one-on-one classes, we'll answer, specifics that is required for you, or we'll teach specifics that is required for you.
Mm-hmm.
Okay. So here the
Yeah.
basics is constitutional law involves two acts and plus unwritten constitutional principles. And you can ask me the same thing 4 times. I'll explain until you get it. Okay. Then
Okay.
under that, as unwritten constitutional principles, one of such thing is separation of powers. So when it all started, no, go back to the history. When it all started, they decided we need three organs, to take care of the
Uh-huh.
entire workload of Canada as a country. What
Mm-hmm.
are those? Executive, legislature, judiciary. So we are now only focusing on legislature for this DOP concept or even charter concept for that. Okay. We are
Okay.
talking about for division of legislative power. We are saying, now again, what is division of legislative power? There are two types of legislature. One is parliament at the federal level. Okay. That is
Presidential.
under section 91, parliament or federal legislature. Okay. Then section 92 talks about the powers to make laws on such categories or subjects by the provincial legislature. That's why there has to be a division. If there is only one person deciding all the laws of Canada, then there is no need of division. It will be under one section. all the laws, the Canada, so and so legislature department can make the laws on all the topics. But it doesn't work that way. Why? Canada is a confederation. Confederation means all the
All provinces
provinces
came
voluntarily they
together.
came together and became Canada.
Yes.
Canada as a country. So even though we have, lot of laws that is different from province to province, just let us
Yes.
take lawyers example. See, we have to, from Ontario Law
Yeah.
Society, we have to follow the Law Society professional rules of Ontario.
Ontario.
People in British Columbia have to follow BC code. People in Alberta has to follow Alberta code. So,
Okay.
because lawyers, the profession of lawyers are governed by the provincial legislature, we come under Section 92. The law,
Okay.
legal profession comes under as a subject matter under 92, right?
Mm.
So,
Yes.
if I talk about 91, example is criminal law. Criminal law is taking, criminal code is there. It is prepared by whom? It is prepared by
The federal parliament
federal
legislature.
parliament. Yes, federal legislature or parliament. So
Yeah.
they have the power to make the law on criminal law. That is why if any province tries to trick into creating a criminal law indirectly, because directly they know they can't do it, because they cannot add it to the Criminal Code of Canada. Instead, they try to enact a law under the province saying that we are actually doing hospital related provisions, but we will give a, punishment of imprisonment for so and so offense. They'll create an offense. We have seen that one of the, what was the case name? Hmm, famous case name?
Morgan Taylor?
Morgan Taylor, yes. Morgan Taylor case law we have seen where Nova Scotia province tried to make abortion as an offense
Yeah.
when it is conducted by the outside the
The
medical
hospital.
hospitals where it is allowed to do, even if the
Mm.
authorized doctor only, if he does it outside it is an offense. So you can't call offense as a provincial legislative. You're not having the power, you're not having the legislative power. Legislative power means the power to make the laws, power to
Yeah.
enact the laws, create the laws. You don't have that power. Either judiciary also doesn't have the power to create the law. They only can recommend the law to the legislature. It's their duty. It is the duty of the legislature. Okay,
Yes. Mm-hmm.
clear? Yeah.
Yeah.
So this is one of the category where we will check whether the law is valid or not.
Okay.
Whether the law is
In
valid
my charter
or
question,
not.
there was the question was also asking for the remedies too, which I don't know about.
Yeah, we'll come to that. Remedies also will get to there. Okay.
Yeah, and I just remembered.
Yeah, good, good. We'll come to that. Okay. I'll just let me do. We'll park it till we finish it. So, whether law is valid or not, we can check if it is enacted by the appropriate authority. If the subject matter is legal profession, and if the parliament is making the law on that, we will say that they are not the appropriate authority. The appropriate authority is the provincial legislature. Then, if the federal legislature or parliament makes the laws on legal profession, then we can say it is out of their out of their authority, or division of power, legislative power is not there, right? Them, they don't have the power to make the law, so it is invalid. It is invalid there.
Mhm.
Second, we can check is charter rights. Charter rights came into picture in 1982 Constitutional Act. In 1982, Constitutional Act is first time where they recognize certain rights and they told these are called as charter rights and you have to follow them. Who has to follow them? The government has to follow them. The legislature has to follow them. The judiciary has to follow them. The three organs, no? There are the three organs of the state. So all of them has to follow. Okay. Of
Yeah.
course, in foundation, you will also study monarch. Monarch
Yeah.
is there on the side. Okay. Outside
Yeah.
this category, basically, monarch had all these power. Then
Yeah.
monarch created these three power, and he's there on the side. He or she is there on the side. Monarch will be over there lingering. They can turn the government anytime, but let us not discuss about monarch in constitutional law. But he's there.
Okay.
Okay.
Mm.
Yeah,
Yeah.
because when you're reading for foundation again, and I don't want you to get confused. Okay, we were told that time only three organs are there. Where did this monarch come from? So monarch is there, but
Yeah.
we don't want to discuss that for this purpose. So there are three organs created by monarch, but all these powers were earlier. Monarch means what? One person can rule anything, right? Do anything, right? So monarch.
Mm-hmm.
So that monarch had all these powers earlier. When we have, in India, we had kingship, right? King. King used to make the law. King used to run the government. King used to give the decisions.
Yeah.
Similar concept with monarch also. Okay.
Okay.
Now, yeah. So coming back to whether the law is valid or not can be checked if the law is made by the appropriate authority.
Okay.
If the law is made by the appropriate authority, right? Then
Mhm.
check for division of power. Check for division of legislative power under section 91. If it is the subject matter under 91, if it is the federal parliament that prepared it, okay, it is allowed. It is valid. If it is section 92 and the legislature is provincial legislature only, then yes, it is allowed. But if it is vice versa, not allowed. Then, second, I was saying, under section, this is under 1867 law, it is under 1982 Act. Hmm? Say CA. Yeah. So, charter rights, basically, there are so many charter rights. How many sections are there, do you know, in charter?
To-
Total
Uh,
34.
34. Okay.
From section 35, the other section comes. So basically, this is nothing but, see, it starts from section 1 to 34, right? So what are these? These are sections from 1982 law, 1982
Constitution.
Constitutional Act only. It is just the starting part. Section 1 to 34, they are categorized and said that we will call as, charter. Like, how we have chapter 1, chapter 2, chapter 3 in a syllabus, like that only. And in chapter also, we categorize, right? In constitutional law syllabus, I told there are four parts. Part 1, part 2, part 3, part 4, right? Part 4 talks about our charters. Part 2 talks about DOP, Division of Legislative Powers chapters, right? There are multiple chapters there also, but that division, that category is called as one thing. Like that, this Constitutional Act of 1982 from section 1 to 34 called as charter rights. But out of these, what are important for us? Important ones are section 1, section 2A, section 2B. 2C and D is also there, but they are not important for our syllabus. And section 7, section 15, right? So these are the
Mhm.
important or relevant sections for us, for our
Okay.
constitutional law syllabus. Apart from this, they don't want you to know anything else. I mean, they don't expect you to know anything else. One and two here. Apart from this, for charter rights only this much, but for your aboriginal part, you do need to know a little bit about section 25 and section 32. Am I right?
Yes.
Yeah. And there is also one more section, section 33. Mm, notwithstanding clause, yeah, section 33. Section 33 is talking about notwithstanding clause. So we'll also list that. So these are the only sections from the charter rights you have to know. You have to have
Understand.
the knowledge of for NCA Constitutional Law exam. Okay. Now,
Okay.
so if any of these sections are violated under the charter rights by any law, that law is not valid. So first question you will ask is if the law made by the if the law is made by the appropriate authority, we will check for this. Second question you will ask is the law violating any charter rights under the syllabus? You don't have to check everything under 1 to 34. You have to check these, only these,
Okay.
only these. Okay? If you check for
Mhm.
these and if these are violating, then you will say, yes, it is invalid. It is not valid if it is violating these rights. And if it is violating and still being saved under section 1, it can be saved, no? Under section 1. Section 1 is basically talking about access. It is a saving clause. Okay. So this is the
Yeah.
broad overview. This is the basic understanding you should have about what is constitutional law. These are two acts and unwritten constitutional principles. One of the unwritten constitutional principle talks about separation of powers, where the state has categorized into three organs, which will have its own independent individuality. They have their own work to do. They will get recommendation from others, but they don't have, they have cooperation, but they don't have joint, association or something. So they have executive, which will take care of the government. We don't want to know about it here in Confi. We have legislature, which is most important for our division of power concept, because division of power, that is division of legislative powers, is basically the power to make laws on certain subject matters which has been authorized to them under section 91 and 92 of Constitutional Act of 1867. Such old act, then only they had decided that, such and such law, the criminal laws will be prepared by the federal legislature because it has to be uniform across Canada. Whereas some of the things like, trade and commerce, again, they have made a difference. Trade and commerce, such and such trade and commerce, such as international, interprovincial, will be going to federal. But if it is purely within the province, we'll call it as, property and civil rights. Under that, we will put it and we will give it to province. So such division they have made on of certain subject matter for you, for me. When I say for you, for me, you are the federal government and the provincial legislature. So they have categorized back then, decades ago, right? Century ago.
Mhm.
So they have made that decision. Then, second question you will ask in order to find whether a law is valid or not. One, whether it is, made by the who made it, who created it, right? Who
Mhm.
created
Yeah.
it? Whether it is Parliament, whether it is
Okay.
provincial legislature. If they had the power to make it, then yes, it is valid. Otherwise, it is not valid. Second question you will ask is the law violating any of the charter rights under the syllabus? Section
Okay.
2A, 2B, 7, 15 plus 1, 15 plus 2.
Okay.
If it is not, let me put this 15 plus 2 in yellow color because that is also saving clause. So if it is
Okay.
not violated under these three things, then it is valid. If it is violating any of these, then we will check. Section 1 saving, yeah, is
What
it
do you
saved?
mean by saving clause?
Saving
So I
clause is
get.
basically, no problem, I'll tell you. Saving clause is basically when a law is violating section 2A of the act. What is section
Mhm.
2A of the act? Right to religion.
Mhm.
Right to religion and conscience.
Conscience.
I have a freedom of religion and conscience. When that right of mine, that freedom of mine is curtailed or restricted by a law, I will call it as invalid law. But the government or the judiciary also, when I go to court and ask, right, so this law is invalid, make it unconstitutional and, throw it in the dustbin, right? I will tell that.
Mhm.
But the judiciary has to see whether it can be saved under Section 1. Section 1 is called as saving law because it saves the legislator from thrown out in the dustbin for being
Mhm.
invalid. It will be saved. What does it say? Section 1 says the
Mhm.
Canadian Charter of Rights and Freedoms guarantees the rights and freedoms set out in it, subject only to, subject to what? Such reasonable limits prescribed by the law as can be demonstrably justified in a free and democratic society. So it's basically, to save its bum, we can say, to
Mhm.
save the law before even telling you about all the rights you have, starting only they have declared. It's like a disclaimer they have given. Guarantee of rights and freedoms depends on this. If it is subject to reasonable limits prescribed by the law. But this reasonable limits now, if you just read this three sentence and one word, right? You can't understand what
Mhm.
they are limiting. That's why we are referring to Oakes test. We are referring to
Oh,
Oakes test because in Oakes test, in R versus Oakes case law, in that case, they have clearly told what is the limitation under Section 1. What is how you can save a law. Four topics they had given, right? 4 points they had given under Oakes test, which we will
yes.
apply, which we will say. But first, what came? First, Section 1 came or Oakes test came? Which came first?
Section 1
Yes, the law always comes first, the case law comes later.
later.
Okay, so Section 1 is basically the basis for Oakes test. Because of Section 1, Oakes test exists. Okay, so Section 1 is the saving clause. So whenever you draft an agreement, you put something to save the agreement, right? So that is called a saving clause.
Okay.
Huh. So section 2, 15 clause 2 also I said saving clause because if any violation is happening under here, when I said, physical disability, they said you can't do discrimination. But my colleague had given one extra hour and one another person to write the exam. So
Mm-hmm.
I say it is a violation of my violation of my freedom of equality, right to equality, right?
Mm-hmm.
But Section 15 clause 2 saves it. I can't actually say that because Section 15 clause 2 is saving that sort of discrimination because they say equal among equals, unequal among unequal. The law
Okay.
is very clear on that. So these are, which I'm, highlighting in yellow, they are saving clauses, but rest of them are basically the rights and freedoms they have given to us in case if, they are to be violated, then we can actually claim that that law is not valid. So under these two things, we will check. So coming back to this question, they are asking us to check for charter violation and tell whether the law is valid or not. So I don't want you to get confused if they are talking about validity of the law. I don't want you to get confused and apply DOP altogether. You have to first
Mm-hmm.
select the IRAC or the notes, right? So what topic actually they are talking about. So first you will see, are they asking you to check for charter or are they asking you to check for division of legislative power, right? So here overall by reading question, did you get any hints about whether it is a DOP question or a charter question?
It's a charter question, but DOP should go through it.
Should not touch upon DOP. So we see we don't have much time for the exam time, right? So examiner basically wants to test you on everything, but they can't mix it up. So either if in case they are mixing DOP and charter, which they usually do, right? 75, 80 marks like that they can do. They can mix it
Mm.
up. That time you have to categorize. They will give question number one, two, three, four, five, like that. Again, they'll say, first you check with and substance. Next you check this one. Next you check charter violation. Like that, they'll tell you. So accordingly, you do that category of answering. Don't mix it up. If you're first answering pith and substance, question number one, only pith and substance. Question number
Okay.
two, you will only talk about starter, right?
Okay.
You will not mix it up. So IRAC will be different. But here it is very clear. It is about discrimination. It is about charter right violation. The Danny is basically the person who is filing the application. Danny is
Yeah.
basically the person who is the aggrieved party. He's she is telling that her charter rights are violated, and no other question is coming out. So you don't have to talk about DOP because we know only so much about DOP here. What is the thing? It is a province
That's
and it is the provincial law. We know only this much. But do you know public housing comes under which topic? We don't know. We have to open the 1982 and 1867 Act and open up and see. It is not our thing here because for DOP also we have certain topics. What are those? Criminal law?
criminal power.
Criminal power under section 91.
Everyone.
Let me write it down. Yeah, 91 to 27. Okay. Then we have uh, trade and commerce. That should have come first.
In
Commerce under 91 2. Okay. 91 2. Then we have what else we have?
property and civil rights.
Yes, that comes under one more is there. No? Power.
Oh yeah, Pope.
Talk power. First, we'll say about all federal. Talk power under 91 opening words.
Yes.
Okay. Then we have
This was my first
92 property and
question.
civil rights. Hmm.
This was my first question with the tariff with the USA and
Mhm.
here.
Okay. Property and civil rights. So they have 92, section 92, right?
Mhm.
Mm, property and civil rights. Section 92, what? What was the subclause? Mm, Section 92. Hmm. In 92, again, provincial powers, we had to see, hospitals, property and civil rights, 13, 92, 13. 13 is main, but remaining also we should just remember, okay? That's why this checklist also you have to print out, 92, 13. What I was looking for. So 92, 13. So these are the syllabus material. These are the only DOP questions you will be, you referring to.
Okay.
Right. In syllabus, they want you to just refer these things, but there are so many other. I have sent you the bare acts, right? So you can check under 91, 92 section. There are so many subclauses, not just 13, not just 27, not just 2. There are remaining also, but they
Yeah.
are not asking us to study all of those now. After you become barrister and solicitor, you should know. That time you should know. But now it's not relevant. So we will stick to what is given to us, right? So when they ask us, in the question, if it is talking about criminal power, trade and commerce, POG, property and civil rights, something like that, if they are specified. But here it is about, housing thing, and it is not coming under any of our syllabus material also, right? Under DOP. So it's very clear it is not a DOP question. And everywhere they're, repeatedly telling that check for what? Check for charter violation, directly they're saying. And consider whether these arguments align with the principles underlying section 1 of the charter. That means section 1 we have to apply, that is Oakes test we have to apply. Because
Okay.
section 1 is rigid, right? Like it's vague, it's not very clear. So we'll take the help of Oakes test to, understand whether it is and aligning with whether these arguments, the arguments of the government here basically to protect that particular law when evaluating the validity. Because ultimately you have to say whether the law is valid or not, whether in charter question also, in DOP question also. You have to say what valid or invalid. But how you can say that? First, you will check, no, whether it is DOP question or charter question. If it is
Okay.
mixed, then we will discuss about that later, right? This step by step we
Mm-hmm.
will see. If it is mixed, first you have to check first. Let's see whether you can answer this question. If it is a mixed question where they are also asking about, DOP topics, and they're also asking about charter. So which one you will check first? Which one should be checked first?
Starting
Out of
with
Hmm.
as an introduction.
No. Which one out of these two? Now DOP question is also there. Charter question is also there. But which one you will check first?
Charter,
DOP
right?
or charter? Okay. Why?
For
Why
this question,
charter?
because it's asking for charter violation and section 1 of the charter.
No, not this question. Generally in exam, if they mix both the topics, then what will
Okay.
you start with? What is supposed to be started with?
Mm,
There is only one
no.
answer. There is only one answer.
Division of legislative power.
Yes. Why?
Mm,
It's a logical question. Okay. It's a logical question. Think if the legislature who enacted this law did not have the power or authority to enact the law at all, even if it is not violating or violating charter rights, do we have to even go till there? No, because first is authority, right? Whether
mm,
I had the authority to do something or not. If I have done something, okay, I have written a letter to you. Did I have, or like, I have signed a document for you. Did I have the authority? Have you given me power of attorney? If you have, for specifically for that purpose, if you have covered for that purpose, then I have the authority to sign to that, whatever for you, right? Otherwise, what
mhm.
happens? Even if it violates some of your rights, it will not be. First of all, it is not valid under, I don't have any authority. So first we will check for division of power, then we will go for charter rights. If it is a mixed question, usually in exam for you, they might be giving mixed question. Okay?
Okay.
They might be
Mhm.
giving mixed question. Why? They might be giving mixed question because they want to confuse you. They want to test your ability to, differentiate the matter, whether you will do a, good job in that or not. That time, one of the mistakes students do is they start with charter sometimes. They're like, okay, let me start with charter. For me, charter is easy. No, you can't do that. Why are you even testing charter if it is not, they are not under the authority of that particular legislature? First of all, you have to see the authority is there or not. Okay, so you go with this checklist. DOP first. Okay, then
Okay. Okay.
charter rights. So they will be giving you questions. So in DOP, fit and substance you have to do. Without fit and substance, you can't move forward. What
Okay.
is the pith and substance of the act? You have to see. Then at last you will see remedy. See, once all these things are done, whether the law is valid or not. So you will answer the conclusion, or finally you'll say at the end of your analysis, you'll say
Mhm.
the law is, oh sorry, the law is valid or invalid. If it is valid, do you need any remedies? If there is no
The law
infringement,
is
do you
valid.
need, if the law is valid, do you need any remedies? If there is no mistakes in the law, and I
Mm.
have taken this case to the Supreme Court also, should I get any remedies?
No, if the law is still valid, then we should follow that. That's the
Yeah. So remedy is basically for grievances. I am asking for a solution. Solution.
yeah.
What is the solution? No solution required if the law is valid. Okay, we'll wind up in 10 minutes. So there is no remedy required if it is valid law. There is only remedy required if the law is invalid. So if the law is invalid, then what could be the remedies?
Mm.
Remedies include include different types of remedies are there in our syllabus under chapter 25, right? What are
Yes.
those? Severance, right? One of that is severance, or we have, hmm. So in remedy chapter, severance, reading down, reading in, striking
Okay.
down, and other damages. Other damages very less. They don't give money just like that. Okay, damage is
Mm.
usually considered as monetary compensation, but not every time it is given. So that's why it's bit more clearly seen. So you have little more concept now. Before giving money, everybody thinks 100 times. So obviously the government also will think 100 times. So, but other things are there. So basically, you should know what type of
Remedy.
invalidity you have found out, like whether they don't have authority at all. If it is a DOP issue, then remedy will be different. Like you can say that the particular section, one section, okay, let's say section 27 of so and so act is invalid because it makes it an offense. It makes it's a provincial law, they don't have the criminal law power, but only 27, section 27 is invalid. Baki sare, like remaining all other sections are valid. So we will keep
Oh,
that and we will sever, or we will remove the bad part. We will take separate. Severance means separate. Okay. We will
okay.
separate the bad part and we will, like, basically the court. Basically, we are not doing it. So court will do it. So they say that we will separate the bad part and we will declare it bad.
Okay.
Okay. So it
Mhm.
will be dependent. Sometimes they will separate only that bad part, or sometimes if it is entirely law is bad, then entire statute might be bad. So that they will decide. Okay. Then reading down is basically, interpretation. They will declare that this should be read, or this should be interpreted in such manner only. Okay, so they will read it down. Reading in is this is limiting the scope down, volume down, right? You are limiting from full volume. So if I say full volume, this is
Mm-hmm.
full volume here, right? And this is
Yeah.
I am keeping it at 63 here. So that is I am volume down. So that is reading down. So that means only till here you can interpret. You can't, the extension I
Remove
have
the whole.
removed. I have removed the extension. Ade, in case reading in means I am increasing the extent, right? I am increasing. If I am keeping it into 100 or 200 also, they can take it. That is basically they are, inconsistency between the law and, yeah. So they are basically reading in, they are adding something that is not there. So one of the case law we can say sexual orientation is one of the violation of uh, equality rights. Sexual orientation, based on sexual orientation, anybody, basically the government, right? So charter is applicable to government or government institutions. It is not based upon like I mean, if I am violating somebody's charter right, I'm an individual, right? You can't claim charter rights against me. Charter rights, based on charter rights, you can only file the case against the government or government institutions. Okay. But if I am a lawyer, already barristers and solicitor, right, in Ontario or any province, is basically, then I am also not supposed to do charter violations, but that will come under our professional ethics. So it will go under a different application. It's an administrative issue. Got the difference?
Um, Not really. Like,
Okay.
according to this case, like Brent versus Alberta,
So, see, in
exclusion
this case, what happened? Sexual orientation was added. So, reading in means they are
was added.
increasing. Yeah, reading in means increasing. That's why I showed volume, right? Volume down. Reading down means decreasing the interpretation. Reading
Okay.
in means they're adding something, or they're increasing the volume. They're
To the
expanding. Yeah. So already we know section 15 clause one has given so many, discrimination categories, right? But
Mm.
now they have added under Brent versus Alberta case law, they have added sexual orientation also. If a person, this is, for 2S LGBTQ plus communities. So in case if they, uh, uh, they are discriminated based on their sexual orientation, it's not just male, female, right? So sexual orientation is different. So based on that, we are not supposed to discriminate anybody. So in this case,
Okay.
what happened? They said that it can be added. So that was one of the remedy they did. They added it. They increased the interpretation of Section 15 in this case.
Okay.
Okay. But what I
Yeah.
was saying is, in case if I do that as a lawyer, if somebody is violating charter rights, then you can claim under their professional responsibility, not under, going to court and filing a constitutional issue. Okay.
Mm-hmm.
Because constitutional issue it will become, or validity of the act and all, it will become only against the government. Because under charter, you have seen the yeah. See, the charter rights basically is applicable for whom? Who is supposed to follow this? Government. Government is
Government.
supposed to follow this, and the state or government, when we say, so they are supposed to not make difference between, a certain category who are protected and certain, other category, right? So that is one another remedy. Then remaining remedy is striking down. Entire law can be removed. Entire provision of
Yeah.
the law in question can be
Yeah.
removed. Striking down. Lord's Day Act. You can see Drug Mart, Bigam Drug Mart case in Section 2A of the charter we have seen, right? R versus Bigam Drug Mart case. So in that, they had removed the entire Lord's Day Act where they held that, basically that law was for what reason? They said Sundays there will not be any business establishment because it's the Lord Day. There was a whole act behind it. And it was valid
Mhm.
for a certain time. But later, when somebody filed a case and, it was considered as a constitutional law issue, and they said that you can't force the religion on somebody who's not following the religion. It was, you can say it is a, irony that somebody the law says section 2A, right? It is protecting or like freedom of religion and conscience. So it is also protecting the people who are not following a religion. You can't force them to follow the religion of yours or any religion. If somebody wants to not follow any religion, they are also protected in the section 2A. It's a very wonderful case law. R versus, Big M Drug Mart case,
Mhm.
we are using it. That's why, sometimes students feel confusion. I understand that, the case law is saying that Lord's Day Act is, asking people to close their business establishments and to follow the religion. It is protecting the religion. Some might interpret it in that way, but no. Section 2A is not just for the recognized religions. You can't say that, okay, this is a Christian, this is a, Muslim, this is a Hindu. So only for those people, they have religious things. What about an atheist? A person who is not following any religion. So Section 2A clearly states that it is not about a religion. It is your religious rights. What you believe in, that becomes your religion. It need not be named,
Yeah.
right?
Yeah.
I
What do you
believe in
believe in?
Buddhism. Buddhism. I believe in, I'm a born Hindu, but I believe in Buddhism. So I can actually claim, my rights and like if I want to. So if I'm in a, particular place, and for example, there was a question in administrative law that guy was in prison and he was following Buddhism.
Yeah,
Buddhism.
I remember that question.
Yeah,
Yeah.
yeah, yeah. He was following Buddhism and he claimed that he needs that, Buddhist chapel for him. So
Yeah.
he can do that. I can claim for that. If I am following that religion, it need not be that I am born with that religion. And even if
Mm.
I am born with that religion or I am following that religion, so far and so forth, I have till now, I had not followed any rules. But from tomorrow, I decide to follow that rules. And my apartment rules are saying that we are not supposed to do something in our balcony, which is that case.
Mm-hmm.
Sukkot. Remember, it was a Jewish, festival. They have to do that Sukkot. They have to do for several days. They have to be in that hut-related,
Yeah.
thing in their balcony. They wanted to do it, but the building bylaws said that no, because earlier they were not doing also. Before that, also for few years they were living in that building. So far, they have not done it. Now they start, asking for it. So people said that, building management said that, no, we will not allow you. But the law said that it is not about whether you have followed till now or not. You suddenly decide, yes, it is my belief. So there has to be sincere belief. So that's the thing. That's the beauty of the case law. It goes into very particular point. Like they will say that, see, here it is about the sincere belief. Did the person asking for this Section 2A freedom of religion and concise, did that person has a sincere belief? Then yes, he will be protected. Here, here in R versus Brigham Drugmart case, why did they strike down? Striking down was the remedy that they gave. Why did they, cancel the entire act? They said that it is not required because it is violating people's Section 2A. The very act which was made for people to follow a particular religion, go to church and certain things. It is a religion, right? It is a religious thing. But that same act was struck down entirely for protecting Section 2A of everybody. Because Section 2A is given for everyone. It's not just for Christians. It's not just for certain,
Yeah, there's
individuals
no need to
following one
relate.
particular religion. Yeah. Okay. The last one
Yeah.
is damages. As I said, they don't give it every places, but they will ask for these four steps first. Okay, these four steps. If it is answered well, then they will give, compensation. Maybe in charter violations also, they might give compensation. See, charter violation, section 7 and 15 violation. So if you're asked for a charter question, if you're asked for
Mm-hmm.
remedy, then check for these. So check for this particular thing, damages. So basically, all these five types of remedies are there. So out of these, you have to choose which is the best for your, case. Or sometimes there may be options also. You can say the court may decide between severance or remedy.
Oh, like that. Okay.
Or you can say severance and remedy. They can remove the unauthorized part or invalid part and also give damages. So that is also there. It is your choice, but make sure that it is not sounding, bad or something. So in the sense, like it should be logical. You can't say reading down and reading in both because they are going in different directions. Reading down is limiting the scope, reading in is expanding the scope of interpretation. So you can't club these two together. So you have to be logical while deciding, but it is your choice. You can say that the court may go for severance, which usually is the best case. If some category only is bad, but in if your entire law is invalid, entire the scope or purpose itself is on certain subject matter which is not allowed for that legislature to make the law, then striking down is best, right? Entire law is invalid, striking down.
Mhm.
Only portion of the law is invalid, severance.
And if the question is not asking remedies, then we don't want to write or we
It's
need to
best
write.
to write. It's best to write
It's
in
best to
two
write. Okay.
sentences. Yeah. So you can check, the checklist I have given for the
Session.
entire syllabus, right? So you have to check all the topics are there. Hmm? So here you can
Yes.
check. Is the remedies there? No, remedies is not there. Remedies is given on the separate point. Hmm, yeah. Okay. So remedy is yeah. Updated material you can see here. Refer to this for remedies. They might sometimes ask a theory question on section
I think I don't
24
have it.
and 25. Okay. This might be in the email. These are all email material, but I'll just send it to you on WhatsApp. Okay. I'll
Sure.
just send it to you again. These are the additional materials I sent 4.1234. And 4.5, then
Okay.
short essay type question and important question. Yeah, these are the additional things. Okay, in
Yeah.
Word file, whatever I've added here, these are the additional things. So I'll just send this to you once the class is ended.
Okay.
Mm, So next class, what you have to do is it's answer you have to type. So you have understood the question, you have understood the concept of section
Uh-huh.
15, right? So now
Yes.
in the next class, what you'll do in the class, you will write. So I wanted to, watch 15 ka lecture, section 7's lecture. I wanted to watch both of those and print out the IRAC that I've given you so that you can have
Okay.
in your hand while you're answering. So think this is your exam, but of course the question is leaked before the exam. But
Okay.
yeah, you have to, answer this. Answer how? You have to use the IRAC method that I've given to you. So same IRAC method, open the section 15 answer, start with the issue,
Mhm.
frame your answer. Let's see how you're making.
Okay.
Okay?
Okay.
Okay. Yeah. I'll
Sounds good.
just, yeah. So I'll see you tomorrow. Yeah.
Uh,